State your name.
My name is Daniel Magoo, for the record, Your Honor.
You're going to represent yourself in this matter, sir?
Yes, sir.
I do have to advise you that in this case, you are charged with the offense of assaulting, resisting, or obstructing a police officer. That is a high court misdemeanor felony, punishable by up to 2 years and or $2,000 fine plus court costs. You understand that?
I understand your charge.
You understand also that there is great peril in one representing themselves. You understand that, sir?
I'm not a...
Whoa, bold move. The defendant straight up calls the judge by his first name, a major courtroom known. This already sets the tone. Defiance, overconfidence, and zero respect for authority. Do you think this confidence will help him? Or bear?
Did you understand what I just said? That there is great peril in representing oneself.
I comprehend what you're saying, Your Honor.
Hey, what? Either you're going to answer my questions and you're going to answer them properly, or we're going to have a long time and I'm not going to have these people wait. So while you decide how you're going to handle this, I'm going to have you have a seat. I'm going to pass your case. You will come back up and you will learn how to operate within this court. Plain and simple. Have a seat. Have a seat. And you might want to wipe that smirk off your face while you're doing it. State your name.
Good afternoon, Your Honor. My name is Daniel Magoo.
I have stated the admonishments that I was giving to the defendant representing himself. I apprised him of the maximum penalties and the charges. Apprised him, and sir, I'll ask you the question again. You understand that there can be great peril in representing yourself.
I fully recognize and acknowledge the seriousness of the charges, which include allegations of...
Not my question. You understand that there can be serious peril in representing yourself.
I recognize what you're saying, Your Honor. I'm fully prepared to proceed with this matter.
Will you just do me a favor and answer my question? Do you understand that there is great peril in representing oneself?
After a full minute of back and forth, the defendant gives the judge the simple answer he's been begging for. This might sound trivial, but it's not if a defendant won't acknowledge basic understanding. The judge can actually revoke their right to self-representation under the Ferretta standard.
I recognize that.
Okay, let's stop there.
Okay.
You recognize.
Recognize.
Do you understand that that in any of the proceedings that the court would hold you to the same standard, practicing attorney will give no leeway one way or the other, will show no favoritism or no bias because you are representing yourself. You understand that, sir?
I recognize what you're saying, Your Honor.
You know what? I don't know why you just won't understand. I'm asking you, and I need a direct answer, whether you understand what I am saying, not whether or not you're recognizing the words. Do you understand what I am saying?
I overstand what you're saying.
You want to be...
Your Honor.
You have a seat.
I'm not...
Have a seat.
Your Honor, I haven't had...
Have a seat. You can play games with me all day. I got all day. I got all day. Have a seat. The other one's in custody. I realize we are now at least caught up within an hour. I think those that want to go probably want me to take a break about now. So I'm going to take about a 5 to 10 minute break. I'll come back out and then I'll call the case. The court's going to stand in recess.
Your Honor, Daniel Magoo. You're in sui juris.
All right. So on this matter, I was apprised you of your rights. I told you about the charges in this case. We get to the point of understanding that there is a certain peril in representing.
Listening, sorry. My notes, I apologize, Your Honor. I meant no disrespect.
And that the court will treat you the same as an attorney in the case. You understand, sir? Listen closely to my question. Do you understand that?
I do not understand.
You do not understand it.
No.
The court, you will be presumed to know the rules of procedure as well as the Michigan rules of evidence, that the court will not be giving you assistance in regard to this case.
What I'm trying to say, Your Honor, is I do not understand the charges that are pitting against me because they violate a lot of my rights. And the prosecutor served me the discovery packet on the 27th of last month. Since then, I have not received any kind of evidence or any kind of claims that I violated any kind of anything that day. So I'm here waiting for that to occur. So no, I don't understand.
Waiting for what to occur?
Well, under the rights to due process, Your Honor, 4th, 5th, 8th Amendment, there has to be substantiated amount of evidence to accuse me of a crime, like assault on a police officer, obstruction of justice, and resisting arrest. I take these charges very serious, Your Honor. Because of these charges, I have lost custody of my...
The emotional heart of his fight. He's not just defending himself legally, he's fighting for his family. But here's the problem. Courtroom emotion doesn't replace courtroom strategy. The judge isn't swayed by feelings. Only by law and facts.
Son, and I want to make sure that these justice is served and equity is ensured here.
Sir, I just asked you before whether or not you understood the charges.
And I answered you, Your Honor. I said I do not understand them.
Whether or not you disagree with them or not the issue. The issue is do you understand what you are charged with?
I do not understand, Your Honor.
Is there a reason other than what you said that you do not understand?
I can elaborate a little further, Your Honor. I'm still waiting.
I wish you wouldn't. I just need to understand why you don't understand.
I'm trying to get there, Your Honor, if we could talk
I'm
about
not asking you whether or not you agree that you should be charged. I'm not asking whether or not you believe that you did it. I'm not asking any of that. I'm asking whether or not you understand what you are charged with.
Can we agree to disagree on the legalese?
We are not going to agree to anything. This is not your game to play here. You play by my rules.
So you're saying that I have to say the words?
This is where things snap. The judge's patience is gone, and you can feel the tension spike. Judges are used to difficult defendants. But once a judge says, "Do not interrupt me ever again," you're skating dangerously close to contempt.
I understand.
Sir, I'm not saying that you have to say anything.
Okay.
You know what? Here's the thing. I am not going to play this game with you.
I'm not.
So what? No, you are playing a game.
I'm not.
So no, you are. And do not interrupt me ever again. Do not. So what I'm going to do is I'm going to give you a week to think about it, because I'm not going to sit here, call your case up 4 or 5 times for you to sit here and to go through this whole, try to play some semantical game. So I will adjourn this out to December 12th, 2024. I will adjourn it to 9 a.m.
Your Honor.
or I will. Do not interrupt me.
I can object to
Do
that date.
not interrupt. Do not. One more time. You're going. I'm giving you fair warning. I'm adjourning the proceeding out. If you are objecting to that, objections noted. It's still adjourned out to the 12th. Bond will continue. You
Your
may
Honor.
leave now.
I have constitutional.
You may
violation.
leave now.
Let's go. Let's do
I have a right to
You
a
may
counsel.
leave.
Do I not have a right to a counsel?
You want an attorney? You may get on an attorney, sir?
I need somebody to explain the problem here.
Do you wish to be represented by an attorney on this?
I do not need to represent myself. I'm presenting myself. I'm the only one that was there in this courtroom. No one was there. I don't recall anybody that was there that day. I'm the only one that knows what happened, Your Honor.
Do you wish
and I was
to be
violated.
represented by an attorney? I'm not going to sit here and argue with you. If you wish to be represented by an attorney,
Your Honor, I have constitutional violations.
Do you wish to be represented by an attorney, sir?
Take an oath to defend the Constitution of the United States of
Then,
America.
if you do not want to answer my question, Mr. Allen, he is to be removed from my courtroom. Court does call the case of the People State of Michigan versus Daniel Magoo.
Good afternoon, Your Honor. Daniel Magoo.
All right. Mr. Magoo, you are representing yourself. I do have to apprise you that you are before the court on charge of resisting and obstructing a police officer. That is a high court misdemeanor, or what technically is known as a high court misdemeanor, and or felony punishable by up to 2 years, $2,000 fine plus court costs. There are great perils in representing yourself. In this, you have to understand that I am going to treat you the same as though you know the laws and the rules of evidence. I will not treat you worse because you are not represented. I will not treat you better or grant any favors or try to clarify anything for you. If for whatever reason during any point in this proceeding you wish to be represented by counsel and cannot afford to hire counsel, counsel will be appointed to represent you. As I have in the past hearings asked you to acknowledge what I've said, I'm going to only indicate that I believe that you understand English. You believe that the words that I have said to you are understood, so that we don't get into, you need to remove the gum from your mouth. And
Thank you.
so I will not ask you to acknowledge. I will presume that you do indeed understand everything that I've said. Now, having said that, what are we doing with this case?
I'd like to move for evidentiary hearing or
You wish to have a preliminary examination?
preliminary examination. Yes, sir.
Would the people have their witnesses available the second?
We can try, Your Honor, but before moving toward that, would the court be willing to make its inquiries about discovery? I am aware of the defendant having filed a writ of mandamus with the Court of Appeals for the state of Michigan.
Yes.
That was subsequently dismissed without prejudice by the Court of Appeals.
Correct.
Contained within that,
This moment perfectly exposes the gap between courtroom reality and what defendants think is fair. He believes missing exculpatory evidence means injustice, but the law only guarantees access, not victory. Should self-represented defendants be forced to pass a basic law test before trial?
so there are allegations that my office has violated its Brady obligations and has not provided sufficient discovery. So I'm not sure if we're ready to move forward to preliminary exam. The defendant is saying that he doesn't have all of the discovery. That is the concern of the court. The record I feel compelled to make at this time, though, is that in this writ of mandamus that has been dismissed, appear to allege that things that have already been denied by this court should be produced. Furthermore, the defendant filed a motion with no notice of hearing attached to it. So there's an outstanding motion in this case as well, no hearing date scheduled. So I'm hoping to sort of reconcile both of those things as whether or not discovery is complete, the defendant's prepared to move forward, and if he ever has filed a notice of hearing to go along with the motion that I received in this case on 11/22.
Mr. Magoo, your response?
My response is that I thought this was the hearing that we were setting for the motion. So if I have to set a motion for a notice of hearing for that motion, I will do that today, Your Honor, promptly.
What about discovery?
I'm ready to move forward on what I meant by my discovery comment was that there's still no exculpatory evidence as far as that I did anything wrong, as far as anything that they've submitted. So if it was improper for the wording, Your Honor, I apologize, but my ultimate goal is have the...
The judge has completely lost confidence in the defendant's ability to argue his case. From word games to confusion about evidence, this hearing turned into a lesson on why representing yourself is rarely a winning strategy. The only thing he's proving is the judge's point.
The prosecution present their evidence against...
I'm going to indicate discovery is complete because I don't know what you're saying, because what you just said regarding discovery didn't make any sense. As it regards the motion, we will hear the motion or the motion will be heard on date of exam.
Thank you, Your
Deal
Honor.
with it at that point in time. So the people would have their witnesses available on the second.
We can try for the second, Your Honor.
Preliminary examination in person, January 2nd, 2025, 12.
Yep.
12 noon, that is before me.
Thank you, Your Honor.
And continue.
The people have provided, I do believe, complete discovery.